without further ado, I would like to introduce our next speaker, John Wilks, who's a senior associate lawyer with a DLA, and he's in the intellectual property group, specialising in IP and media litigation, data protection, and related issues. His client base includes the Premier League, so presumably that means he gets good tickets for football matches, Kraft, Honda, and the Financial Times. He's also a member of Marks, and I think through that role has been following the development of the GTLD programme very closely. So John, thank you very much for joining us, and look forward to your presentation.
Thanks very much, Emily. Yes, it's time for the legal bit. Now, as I'm sure you'll appreciate, this is not going to be the sexiest part of today's presentation, but be assured that I'm going to spare you some of the piles of detail that you can imagine is in this thick document that Emily showed it you earlier. I'm going to be really focusing on some of the key legal issues and suggested practical steps for companies. And these split into issues which are specific to applicants, those issues which are relevant to both applicants and other brand owners who might make the decision not to apply for a GTLD. So even if you are thinking, well, for whatever reason, be it cost or whatever, that this is not going to be something that your company is interested in getting into, there is going to be content in this talk that is relevant to you as well, both relating to the GTLDs, the bit after the dot, as I'm sure you're all now aware, and also to second level domains, the bit before the dot. Then finally, I'm going to sum up with a few suggestions from a lawyer's perspective for brand owners and a summary of the critical dates. As has been mentioned by Emily and others, the source of all the information on this topic really is the applicant guidebook, which of course has gone through various iterations, and ICANN have done really well to bring it back down to a mere 349 pages now, which is a great development, and was last updated just on the day or the day before the application window opened in January. I can't say that its 349 pages are a riveting cover-to-cover read, but it is the authoritative source of any information about the whole regime, and you can print it off from ICANN's website if you do want more details. So just starting with some issues that are relevant particularly to people who are going to, or companies that are going to apply. Now, across my firm, we have a focus group of people in different jurisdictions looking at the GTLD opportunity. And some of the legal issues here come from either ones that clients have raised with myself or with my colleagues. So firstly, there's the issue of determining whether your chosen GTLD is registrable or not. And I'm going to come on to explain about what types of name are likely to encounter problems in the context of talking about the complaints procedure. But in short, you're going to want to do, before you commit this very significant investment, you're going to want to do some pre-registration searches as a minimum, in the same way that you might want to do if you start to use a new brand in any other space. There's plenty of legal issues flowing out of the application process itself. So there's various contracts that need to be put in place with the registry service provider who's providing the kind of back-end technical support. And then there's a requirement to put certain data in escrow. So you'll need an agreement with an escrow provider, and there might be consultants who'd want to engage on various aspects of the application process. It's also important to bear in mind the confidentiality and data protection issues. Firstly, at the stage of the application, there are certain parts of the application that will be made public on ICANN's website. And so you need to be comfortable about that. But also, going forward, if you were to operate an open registry, by which I mean one where third parties can register second-level domains within your registry, which is perhaps going to be more likely to be the case with a truly generic TLD as opposed to a brand-based one. But then there are various other concerns in relation to data protection which flow from the agreements with the end user who registers a second level domain. But also then, if you're organising an open registry, you need to also be aware of the need for various pieces of documentation, such as registrant terms and conditions, and a dispute resolution procedure for disputes relating to second level domains within your top level domain. Just to give you a couple more idea of issues that may crop up during the application process itself, there are various potential challenges that may be raised. Firstly, by there might be effectively challenges to your application by the evaluators themselves, who might say that your application fails the initial evaluation because you haven't complied with some of the formal criteria that Rolf is going to talk about in the next session. And there is then an option to extend for a further evaluation. At this stage, you're not really looking at trademark issues, more these formal criteria, such as whether you've provided sufficient company, technical, and financial information. Then there is also the possibility of challenges by third parties, and I'm going to come on to the objection process in the next section. This is certainly where brand owners would be looking to potentially oppose GTLDs which they think conflict with their rights, but as we'll see, there are also other people who might be able to raise an objection. So we're now going to focus on legal issues which apply to both applicants and other brand owners who may not be intending to apply for a TLD. There's two types of issues here, really. Firstly, there's issues relating to the GTLD itself, and secondly, there's issues relating to the second level domain, the bit before the dot. So I'm going to start with the objections to the GTLDs and we're now talking about during the application process. There's a table there with obviously quite a lot of information on, and I'm just going to take you through. These are the 4 types of objections, and you can see them listed on the left-hand side there. The first one is what's known as string confusion. So this is what happens if United Airlines and Manchester United both apply for .United. ICANN has said that it will not register both. For technical reasons, it cannot register both. And so the issue is obviously that the GTLD applied for there are 2 people who are applying for the same GTLD. Now, there are detailed rules for how to decide how the TLD should be allocated, but essentially there are 2 main criteria here. One relates only to the situation where one of the applications is what's known as a community application, which was touched on by Kurt and Olof earlier, which is where there is an organisation which represents a community. And in that situation, the community application is submitted to a scoring process based on various issues, such as how genuinely it represents its community that it's applying on behalf of, whether there is genuinely a community that it is representing. And if the community application is found to be with merit, then that will trump a non-community application. If that phase doesn't manage to resolve the issue and the parties don't manage to agree which TLD should be registered between them, then the final tiebreaker, as has also been touched on, is an auction with the domain going to the highest bidder. So now the next line there is legal rights. So this is the key one for brand owners. And there is a test which has been based on concepts from both European and US trademark law, which is essentially looking at whether the GTLD applied for would infringe registered or unregistered trademark rights. There are various concepts from, as I mentioned, from existing law in both sides of the Atlantic, which have been employed there, such as whether the applicant would be taking unfair advantage of or impairing an earlier mark or creating a likelihood of confusion, but I'm not going to go into the details of that test here. The third type of objection is a very limited public interest objection, which would really apply in situations such as where somebody applies for perhaps a word which is actually very offensive in certain countries. Anyone can make one of these objections, and for that reason there's a kind of a quick look weeding out procedure to see whether this is a genuine exception or really just somebody making a frivolous or vexatious objection. Then the fourth type of objection is the community objections. So, I mean, just completely taking a random example, if somebody applies for .Mormon and they're nothing to do with the Mormon community, then the Mormon community might very well be likely to complain about that, and that would be a community objection. And in order to launch one of those objections, you have to show that there is a well-established community, there is a strong association between the community and the TLD which is applied for, and community here is interpreted in quite a wide sense. And so that you're looking to show that there is a clearly delineated community and a strong association between the community and the TLD. One final point to note is that on the right-hand side there are, and here we get into these acronyms that we've heard lots about already, but these are basically the bodies which are charged with deciding any disputes in relation to whether these GTLDs can be objected, and you can see that there are different bodies that are charged with that responsibility depending on what type of objection we're talking about. So, as has also been mentioned, the 1st of May this year is of all importance if you are interested in looking at whether your brand has been applied for, or perhaps if there is a generic TLD, as Ben mentioned, that might have been applied for, which you might be interested in either opposing or perhaps later down the line getting a second level domain within. On that day, as I understand it, the applications are going to be published on ICANN's website. So that's just 2 weeks after the or just 3 weeks perhaps, after the application window closes on the 12th of April this year. So then there's the evaluation procedure, which has been mentioned, lasts for about 5 months, and then there will be a deadline for filing objections, which have to be filed with the relevant dispute resolution service provider, those organisations on the right-hand side in the last slide, by the 1st of December this year. So you've got a bit of time to work out whether there is a domain there that you want to oppose if you are in a position of not applying and watching what others are doing. If you do want to file an objection, there's going to be a fee which will depend on what type of objection you want to file. If you're basing it on legal rights, so trademark rights, the indication from WIPO, which is the organisation, the UN organisation which is charged with administering the trademark side of the objections, they've indicated that there will be a $10,000 fee for filing one of those objections per party, but you get $8,000 of that back if you're successful. So then what's going to happen as objections are filed between the 1st of May and the 1st of December is that the dispute resolution service provider who is in charge of that type of objection is going to publish some details of the objection on its website. So you can also look out to see who's opposing or who's objecting to what. And then once the objections have been filed, from the 1st of December, there's a 30-day period in which applicants, the applicants who have, unlucky applicants who've had an objection filed against their application can file a response to that. And normally it's a written procedure which is decided on paper. So that now moving on to look at the second level domains and how you can prevent applications for a second level domain. The GTLD registry providers must, as a minimum during the startup phase, adopt these measures. I should mention that this applies to registry providers, so the GTLD registries who have, so those owners of GTLDs are required to provide these if they are allowing third parties to register within within the domain. If you're solely a brand who has decided it's not going to let any third parties register second level domains within, then the sunrise period is not required. But if you're allowing third parties to register, so your domain is open, then you have to provide what's known as a sunrise period. I suppose there's a potential problem, just to give you a bit of background, where you have an open registry. So if you take an example that Facebook register a GTLD and then allow anybody to register their brand.facebook. The concern is that a cyber squatter takes the name of the brand, of your brand, and registers your brand.facebook. There's obviously potential huge problems for brand owners in that lots more domains are going to be suddenly rolled out, made available at different times, and we've heard that this is going to start the delegation delegation procedure when these domains, these GTLDs go live, is going to start from early 2013, and the estimate is that there will be about 10 new GTLDs per week that are rolled out as the 500, the first 500 batch are rolled out. So as a brand owner, you're going to need to keep your eye on what is being rolled out when. Now, to deal with this potential issue, the ICANN agreement that each GTLD registrant must sign says that GTLD owners must, if their registry is to be open, firstly provide for a sunrise period, which is a 30-day period before the launch of the TLD, to allow rights holders to register their names as second-level domains within that TLD. And after the launch date of the TLD, there is a 60-day period in which there's something called the Trademark Claims Service, which is provided. And this basically provides notice of registered rights to potential registrants. So when when somebody applies for a second-level domain, which is the same as one of the trademarks which has been registered in something called the Trademark Clearinghouse, which I'm just going to come on to, then the potential registrant, if you want to apply for a second-level domain, you're given notice that somebody else has prior trademark rights. And this Trademark Claim Service also provides notice of domain registrations to the rights holders when the application has been granted. So there's two kind of mechanisms here which interrelate. There's the sunrise period and the trademark claims, which can only work because of a completely new innovation, which is part of the whole GTLD process, which is called the Trademark Clearinghouse. This is going to be a centralized database of information about trademark holders' rights. Incidentally, I mean, certainly from an IP lawyer's perspective, this is quite an interesting development. Up to now, if you wanted to know about trademark rights, there are various publicly available, well, there are various subscription databases you can go to, or alternatively, you have to go to the national trademark registry of a particular country to find out if marks are registered. Whereas what's going to happen here is that trademark owners are going to be able to file evidence of their rights. They'll have to pay a fee for doing so, and we don't know how much that fee is going to be yet, because it hasn't yet been decided which organisation is going to provide this trademark clearinghouse. But basically, brand owners will be able to file evidence of their trademark rights, and then this database is going to be open, as I understand, freely open for any member of the public to inspect. So on the one hand, this is going to be an open database. Also, it's going to enable the registry owners to comply with their obligation to give notice to potential registrants or when there is a prior right that their second level domain application might compete with. So, and in addition, another aspect of this trademark clearinghouse is that in the dispute resolution procedure in relation to second level domains, which I'm just going to come on to, rights owners can to some extent rely on the evidence of trademark rights which has been filed in this trademark clearinghouse. So now there are, these are the main options if you are a brand owner and somebody has registered your brand dot whatever the new GTLD is, whether it's your brand.facebook or whatever. So you have these three options. The first one is the Uniform Dispute Resolution Procedure, which is the existing one for .com domains and certain other top-level domains. And so that's kind of tried and tested. And the basic test there is whether whether the domain which has been applied and registered is confusingly similar to a trademark and registered and used in bad faith. You still have the option to apply to a competent court, but then there is also the new innovation, which is known as the Uniform Rapid Suspension Procedure. Obviously, there's an acronym there, URS. There's some sort of difference of opinion as to how far this is really going to be relied on by rights owners who want to challenge a second level domain. But the idea here is that it's going to provide a quicker alternative to the UDRP, which can take perhaps a couple of months to get to a decision. The URS is intended to be streamlined and an expedited version. It's only going to apply to registered trademarks. So if you have some unregistered rights, such as passing off rights that we have in the UK, or unfair competition rights, as you might have in other jurisdictions, the UDRP would be the only option for you. But the idea of the URS is that you can get a decision just 5 days after the response to your complaint has been filed. So that's we'll watch this space as to see how much uptake there is for that. So now, just in the last few minutes, I'm going to give you a few thoughts on how you might formulate what I've described here as a legal strategy for protecting your brand. As you'll have gathered from particularly what Ben was saying earlier, these issues are not really issues that can be considered by your in-house lawyer or your trademark counsel in isolation. These are clearly issues where there's a big overlap between the communication marketing side of your business, the information technology side of your business, and also to some extent the finance side of your business, because both the decision whether to apply and also which domains to apply in relation to will have considerable financial implications. So obviously the first and most pressing need for a brand owner is to decide, are you going to apply for a GTLD or not? And as Ben also mentioned, to work out if you are going to apply, well, what are you going to do with it? I think the two questions clearly go hand in hand, and you almost need to answer the second before you tackle the first. And there are clearly various options there. Are you simply going to register it as a blocking mechanism? Are you going to have it freely open to the public, or are you going to go somewhere in between? If you are perhaps a franchise operation, you're going to allow your franchisees to register second level domains within it, or perhaps in a distribution situation, are you going to allow your distributors and retailers to register second level domains within your GTLD? And those questions very much are going to have to be worked out now, because there are various questions in the application process that have to be answered on that topic. It's definitely a good idea to have a company policy as to going a bit further forward into the future. which domains to apply for, and obviously you need to decide which GTLDs to apply for, but also what second-level domains and which to dispute. Obviously, in that analysis, you're going to have to deal with the issue that everybody has finite resources, and you might have an existing policy for the current world of 21 GTLDs and about 100 CCTLDs, and then suddenly we're going to be evolving very rapidly in the early part of next year to a world of at least several hundred. It's, you know, people are running a book on quite how many are going to be applied for, but certainly a lot of people seriously think that the number is going to be upwards of 1,000 TLDs applied for. So obviously, if your current policy is that you're going to register just in relation to your brand and perhaps some obvious spelling mistakes, you're going to need to move that on in terms of the scale of the available domains is going to massively increase, so you're going to have to rewrite your policy on that front. So obviously, check the list of GTLD applications on the 1st of May, both from a perspective of whether you want to oppose those, and also from a perspective of what second-level domains you might either be concerned about or want to apply for yourself. So there's the question, once the reveal day has passed, whether you want to object, and you have the 1st of December deadline for that, as mentioned. You can also, as I mentioned, look to see who else is opposing or objecting to particular GTLD applications. It would be sensible, certainly, to use the clearinghouse and the sunrise periods that we've mentioned earlier to make sure you secure any second-level domains that you want first. And more generally, my recommendation would be to see what others are doing. As Ben mentioned, it's a totally evolving and unknown situation in many ways, and so staying flexible and taking appropriate action in response to that is definitely going to be key. And then finally, it's a good idea to diarise those key dates. And they're just summarised there, but I suppose the main one's 1st of May and the 1st of December, and then to expect all this to be suddenly rolled out somewhere in early 2013. So that was all I was going to say. I'm happy to take any questions now or at the end in the panel session as we've talked about.
John, thank you very much for that. Incredibly efficient canter through an enormous amount of information. So congratulations on that. So thank you very much.
Thank you.